So we're going to begin looking at the first section, which is formation and parties with Lumley and Foster 2022. Who is the contracting party? Now, this was a lady who contracted, very modest contract, really, just barely high court value at all, could have been done in the county court possibly. And she contracted with somebody called Mr. Foster, who had not just one, but about 5 different companies: Foster Group, Foster Building, Foster all sorts. And various company names were used during the negotiations, but he was a constant. So he referred to making sure that everything would be done properly, and he would oversee everything and so forth. And he gained her trust. So at the end of the day, although the claimant sued 5 or 6 different entities, including Mr. Foster personally, it was Mr. Foster personally that entered into the contract. Simple rule. And we'll come back to it at the end when we do execution blocks. Rectification is not available. If you get the execution block wrong, it is not going to be easily put right. Privity kicks in. The rule is that unless you say for and on behalf of, it's the party who is negotiating, it's the party that's referred to in the contract. If it's a written contract, this one wasn't, in the document, and that is it. So you've really got to be careful about making sure that your capacity for and on behalf of ties in with the name of the contracting party. It's a reasonable test. Just on our indemnity piece there, we have Gwynty Moor, which is a Welsh offshore farm for wind. And it's really poor drafting, actually. What they talked about was pre-completion damage. Well, pre-completion damage. Really what you mean is post-exchange pre-completion, because you've warranted against what you've inspected in terms of the assets. You've got a disclosure letter that's fixed in time. Anything else is working off to that point. And really what they wanted to do was go right back to the time that the apparatus became damaged. And of course, well, you've already inspected it, you've seen what it is, so you know what you're buying. Sold as seen, sold as warranted. So that kind of exercise of interpretation was far too broad to be accepted. And the reason was that if you look at the warranty, and because normally the indemnity in an SBA mirrors those warranties, it kind of sweeps up the damages from the warranties. That will give you a good clue.